Everybody. Obviously, you just took your quiz, and we're going to be kind of going over your next assignment. We'll go over this on Monday. This is not your guys' guided notes or anything. You can obviously refer back to this, or you can take notes on your own, whatever you want to do. But we're going to go over like different rules of evidence and objections. Like, so, for instance, when you're up and you're in front of a courtroom, and you're a prosecutor, or you are a defense attorney. You can't just like throw out any evidence you want and say what you want to say. There's rules that people in the courtroom have to follow. So why do we have these rules of evidence? So these are things that we're going to incorporate into our mock trial coming up. All right, so why are there things such as evidence rules? Like how do you present them? What can you present? The reason is most important is it always comes back to the purpose of ensuring a fair trial. If you're a prosecutor, you only got one shot at this. If the defendant is found not guilty at their trial, you can't retry him. That is something called double jeopardy. So if you mess up, you don't follow procedure to ensure that fair trial that the defendant deserves and as part of their constitutional right, then you could be in some deep doo-doo. So that's the one thing why there's procedures, why there's guidelines. And obviously, we want to make sure that we're keeping out things that are unreliable. Or that is prejudice towards the defendant. Obviously, you want to make sure if you're presenting something, there's a sequence of events you must go through in order to get that cleared to present. So here's the first thing. So have you ever heard, if you ever watched like Law and Order, about how I object. So this is one of the things that lawyers would object upon is something called a leading question. You cannot, as a lawyer, either side, ask something called a leading question. So what does that mean? It basically means these are questions that suggest what you want the answer to be. So these are not allowed during direct examinations when you're direct examining your witness. So here's an example of a question, but asked three different ways. So if you were to ask, is it true that you locked the door when you left the house? Obviously, you're leading the witness to answer how you want to answer it. Of course, you're saying, is it true that you locked the door? Okay, you can't ask that question. That is something that is objectionable. Now, a better way to ask the question is, what did you do, if anything, when you left the house? So obviously, that the witness should say, if that happened, that they locked the door, that they'll say it at that stage. Again, you're not leading them into what you want them to say. Now, the best way to answer the question is, well, what did you do next? So again, I'm hoping you're kind of seeing that. So when you guys are writing your questions, and I don't care if you're a witness in the mock trial, if you're a lawyer in the mock trial, you guys are all going to be writing questions. Do not ask leading questions. That's important because that could be objectionable during the mock trial. The next one that you want to avoid is something called argumentative questions. This is when you are not allowed to badger or harass or argue with the witness. If the witness is being hostile and being a smart aleck, then you can rephrase your question to get them back on track, or you can ask the judge to impeach them if they're being really inappropriate. But again, you as a lawyer, it's your expectation to be professional. You can't be accusatory towards them or calling them names like, "Don't lie to me. You were stupid and you drunk and you ran the red light, didn't you? Didn't you?" Again, you can't do that. So again, that would be objectionable. The other lawyer would say objection. That is argumentative. So we have that. Next one is speculation. You can't ask the witness because again, most witnesses are not experts. They cannot give their opinion about something. Why they're called up to the stand is what they saw, what they heard, what they smelt, whatever the case might be, or what was said. So these are questions that require the witness to guess. Again, you can't ask those questions. So example of this is, would the driver have had time to slow down if he saw the red light? Again, how can that person know? That's a subjective question. So obviously that would be, I object, speculative. Now a better way to ask the question is, where was the driver when the light turned red? Was he 20 feet back? Was he 5 feet? Was he right at the light? So again, that gives some context. Again, you're not guessing, you're telling them where they were at and letting everybody else kind of draw their own conclusions. Narration. This is where a witness gives more information that is necessary. So like, the question is, where do you work? And this person went on this long thing here. I'm not going to read this to you. You could read it yourself if you're really that interested. But again, you want to make sure that the witness is answering the question, keeping it short and sweet. You don't want them going on this long rant. Basically, keep it to the point. So, I object, narration. The judge will give his opinion. Sustain means that the objection is upheld. Relevance is also important as well. So your question as a lawyer has to be relevant to the dispute, to the issue that's being discussed. So again, for instance, objectionable. What's your favorite coffee shop in Seattle? Okay, well, what does that have anything to do with the case? Again, that's just an example. So again, you want to make sure that your questions that you're giving them is relevant to the charge. So for instance, you call a witness up and you start asking them about things that happened when they were a juvenile that has nothing to do with the case, basically trying to hurt their credibility by bringing up their childhood, maybe rap sheet or crime sheet. That wouldn't necessarily be relevant to this case. All right, so that's relevance. Hearsay. Hearsay means that statements made outside the courtroom are generally not allowed. Again, objectionable. The bartender told me that the driver had been drinking all night. Okay, well, is the bartender there? If the bartender's not there to give that statement, you can't give it for him. So that's very important. You can't use it hearsay. If somebody's in court giving testimony, you can't say what somebody else said or what they saw. So like the bartender said that they saw Johnny walk out. No, well, where's the bartender at? The bartender needs to be up in the witness stand to say that in order for it to be credible. I hope that kind of makes sense. There are some hearsay exceptions. So exceptions to that, statements made about an event when it happened that demonstrates the speaker's intent, knowledge, or belief. So admissible. After he got out of the car, the driver said, "I'm sorry, I didn't see the red light." Okay, so that would be admissible because you're testifying what the driver said. Statement made by a party in the case if it goes against his or her side. So the next day, the driver told me she had been texting her boyfriend, so she didn't see the light. So I'm kind of hoping you kind of see those differences there. So those would both be hearsay exceptions. First-hand knowledge. Witnesses must have directly seen, heard, or experienced something to testify about it. So again, objectionable. Everyone has been talking about how the driver ran the red light and caused the accident. A better way to say the question is, I saw the light turn red while I was in the intersection, and the driver was about 100 feet behind me. A few seconds later, I heard a huge crash. So these aren't necessarily just questions. It could also be statements as well from the witness. So you got to be careful with how you answer these questions too. So again, you want to make sure that you have firsthand knowledge about what you saw and what you experienced. Opinions. These are only reserved for people who are expert witnesses. So if you're a scientist, a psychiatrist, a ballistics expert, whatever the case might be, if you're asked, like what does your expertise tell you, then that's reasonable. But examples, something that is objectionable, the driver was definitely too drunk to drive. Well, how would I know that? If I'm not an expert at that. You could say she seemed drunk to me because she was slurring her speech and couldn't stand upright, but I don't have any firsthand knowledge of her being drunk. So no opinions on how the case should be decided. Do you think that the driver committed second-degree murder? Again, you can't ask that question to a witness. Do you think this person should be charged with first degree or second degree? No, that's not something that should be asked. Going beyond the scope of cross-examination. So when you redirect limited, you're limited to topics discussed during cross-examination. In a real trial, cross-examination is limited by the topics discussed in direct. So you're keeping your topics really limited on what you're able to do. Okay, so again, just to kind of reiterate some major things. So when do you object? The attorney questions witness gives an answer, and the attorney's admitting evidence. So these are three stages. You can do it when the attorney questions a witness. You can do it when a witness gives an answer and meets one of those criterias. Or three is when the attorney admits some kind of evidence that you think violates the rules. Now, how do you object? You stand up, you address the judge, you state the violation. So stand up, I object. Object on speculation. The judge, and give a reason, and then the judge will say sustained or denied. When you introduce physical evidence, these are written documents, diagrams, or other items involved in the issue. When you want to present evidence, that's kind of what we're talking about: written documents, diagrams, things of that nature. You want to mark for ID. You want to show to the opposing counsel. You want to build a foundation with the witness. You want to hand to a witness, ask witness if he or she recognizes it, ask witness to explain, describe evidence. So, by the way, for your mock trials, there's going to be a picture diagram of the store. So if you're the prosecution, you might want to print that out and talk as you talk to your witnesses in your interviews. You can kind of just make them be ready about what you're going to ask them in terms of that evidence. And you're going to admit it evidence as an exhibit. So Exhibit A, here's my diagram, and you're going to basically formulate it to the court about keep it on the record. You could also impeach a witness if somebody is being, it's basically meant to discredit the witness. You show motives for lying. You're showing inconsistencies in testimony. So if a witness is giving a false answer, or being hostile, that's when you might impeach. All right, so that is it. So what you're going to do in Google Classroom on the same post, and it's not posted yet, guys. It's on the exact same post as your test, as you guys see right here. This is where you're getting this video. You're going to see there's going to be another sheet for you guys to fill out. That will, it's 6 questions over examples of objections. So do your best on it. We'll go over it on Monday. Anyway, have a great weekend, and I'll see you guys on Monday.